Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. Got some great stuff on the table. Of course, some great guests. No one's covering it like the Law&Crime Network, gavel to gavel. Oh, great. Thank you very much. Listen, probably the most important show that during the time that I host can only be described as my introduction of my next guest, the infamous hashtag 4041. Having shot all those great points as an all-state basketball player in high school, an all-state DOJ guy for 30 years, the Gene Rossi War Room. Gene, welcome back to the show, Law&Crime Analyst.
I can't wait for Final Four to start.
Well, listen, I mean, why watch that when you can watch some of these fascinating trials, Gene? And just as a little sidebar, today a very important event is happening in the college cheating scandal. You may recall that case. It was just a breathtaking, wide scandal that ensnared this Huffman, I forget her first name, and Lori Loughlin, and they're accused of basically paying money. Huffman in the amount of $15,000 to fake SAT scores, Loughlin in the amount of $500,000 in bribes to get their two daughters in via a fake process where she was being, the kids were being told they were on the crew team, and therefore they were able to get these kind of scholarships or bumps, if you will, into the school. They were each undeserving kids. They did not deserve to be there. They took seats away from kids that should have been there. Gene, I was just recently doing a hit on this subject, and you know what I looked at them like? I called both of these people and the other parents that participated in this armed robbers. Armed robbers. A little different than what we normally think of armed robbers. Arms were filled with cash, and that cash was used to give to people illegally to rob deserving students of their positions in the school. I think it's pretty disgusting, and as the head prosecutor, if this case came across my desk, I'd be looking to make a message that the rich and the privileged cannot get away with taking things from those who work hard to earn things. I'd be looking for prison time. What are your thoughts, Gene?
I'd be looking for a lot of prison time. And Bob, you know what I'm talking about. We had a lot of cases presented to us involving victims and violence and, you know, murder, rape, things like that. And of course, your heart just bleeds. But whenever I got a fraud case with categorical, just pure greed and deceit by people who had no reason to act like that, I would go for the hammer, because they have no reason to do what they did. They don't need the money. They don't have a unsettled home. They have all the gifts in the world, and they still cheated. That really offended me to no end.
What a message, because for those of us who have grown up with the right ethics and morals, our parents tell us, you don't have the grades, you didn't make the team, then move on to something else. You don't deserve to be there, as opposed to mommy and daddy spending money. You know, Gene, I know you're a literary guy. I know you're a food aficionado. I know you're essentially the Renaissance man in the legal profession and here at the Law&Crime Network. This reminds me of Dante's Inferno, where the lowest rung of hell, all the way down before you get to Satan himself, is the person who commits fraud, the person who takes advantage of those other people. With all the crimes we can think of, these kids, as you've indicated, had everything in life. And I, as far as a justice question, ask you, what about those disenfranchised kids that we prosecute? What about those kids that don't have money, don't have access, don't have great education, kids who didn't know any better, that got caught up in minor crimes and go to jail? I can't, as a prosecutor, put those people in jail and let these folks who had everything slide.
Absolutely. That's why I had so much passion and determination in prosecuting people like this. Now, to be fair, we're both criminal defense attorneys. You know, they're assumed and presumed innocent, but the allegations in that U.S. Attorney Office's indictment in Boston, they're pretty bad. Yeah. And I got to tell you, it's going to be a tough case if they go to trial.
Of course, they are all presumed innocent, but how the mighty can fall pride coming before the fall. I don't know, Gene. I think they got a pretty solid case from what we've read so far, but we will wait and see. Now, the guy's in the chat room, and if you're not in the chat room, you're making a mistake, because you can watch how they were laughing at me before, because I didn't say Jonchuck's name the right way. They're right. But nevertheless, we are covering that trial, and some very fascinating things occurred, as I said to you before, with regard to his competency right in the middle of a case. I can tell you as a prosecutor, this is the last thing you want. You certainly don't want a mistrial because you can't proceed. And moreover, you know there's an automatic appellate issue that's being created right now if the court does proceed with the trial. It's going to be pretty fascinating. Let's listen to the defense's arguments and discussion to the court about what it was they were observing that led them to the conclusion something's not right with this guy.
Even though Dr. Otto did not identify Dr. Lazaro by her name of Emily or make reference to her in any regard, I think we can all see why one might be led there as opposed to just picking something out of the sky. Do you have any questions? Dr. Perman?
No, Your Honor.
Dr. Perman?
I do not.
Does the state want to put anything else on the record?
No, Judge, we understand that it usually has to be under the rule written, but obviously they can't do it written in the middle of the trial. We appreciate them putting on the record everything that they can provide for the doctor to make that determination.
Okay.
And we'll go from here and see what happens.
All right. So you're going to look at him?
Yes, Your Honor.
Now, so I will formally appoint you to examine Mr. Jonchuck for purposes of competency to continue on with his trial.
Yes, Your Honor.
Thank you.
Yes.
All right, welcome back. So, Gene, essentially his defense attorneys, they seem pretty well documented, talking about it's not just one singular thing, it's a number of things, including the previous incompetency issues, him thinking that the witnesses are saying things that they're not saying, it caused them to actually get a confidential and independent investigation both before the trial and then during the trial. There's inappropriate laughter. Now, I know the audience here may think that lawyers kind of like this may be a little game playing or whatever, but I can tell you by the way it was being presented, these lawyers did this as they should to protect themselves as professionals as well as the client's rights. And they're telling the court, we have concerns as to whether he's understanding the witness's testimony. That's a bad place for the defense attorneys to be.
Oh, absolutely. And I want to educate our wonderful listeners and viewers. Under a case called Cooper versus Oklahoma, in 1996, the Supreme Court said that competency is a burden on the defendant by preponderance. And I don't know what Florida, I don't know if they follow that, but anytime a defense attorney has questions about the competency of their client, they have to raise that because the law presumes that a defendant is competent to stand trial. So basketball, the ball is in the defense attorney's court to show that he's not competent. They did a great job. She laid the record, and then we'll see where it goes.
We have a fascinating case, as always, on the Law&Crime Network. Hey, Gene, we got to do a little business here, but we're going to come back on the other end of the break with more Law&Crime. That's the radiologist under cross-examination by the prosecution in the Lindsay Parton case. Gene, what do you think?
Well, a couple things. Number one, I thought the cross-examiner was doing a very good job of controlling the witness. There were a couple of testy exchanges that I thought he didn't need to do, but he's locking her in. Number two, I just remembered this. In Florida, correct me, Bob.
Bring it in quick.
In a criminal case, you can take depositions in criminal cases. And you can use it against them? Absolutely. Because, sorry, Gene, got to go to break. We'll be right back. Okay, welcome back. That's the court's forensic psychologist breaking down the conclusion that he believes the defendant is competent to continue with his child. Gene, what do you think of his testimony in terms of, and explain to our audience why he was asking the questions he was asking? He just wants to make sure, number one, that he's lucid. Number two, that he understands basic concepts like an indictment, allegations, and he asked him about what a guilty plea was. Just basic things to get out from him that he is not delusional, he's not seeing demons, and that he can understand what's going on in the courtroom. They were very good questions.
Right. Understanding the nature of the proceedings is really the bottom line to a competency to stand trial. Of course, again, I emphasize competency to stand trial and insanity defense are completely different legal animals. Let's listen to some more of the doctor. Okay, welcome back. So that is the court-appointed psychologist that also, there's been two medical experts had an opportunity to review. The fact is this doctor, as well as the first doctor, come back as him being competent. So that is both a psychiatrist as well as a psychologist, which is what we were just listening to. Listen, we're waiting to get back for court to resume in the Jonchuck trial. Gene, I'm curious about your opinion about this, and I think it could vary from state to state. But do you see, let's get to a really nuanced thing here. We know competency to stand trial deals with whether you can assist your defense meaningfully at a trial, where insanity is at the day of the incident, whether or not you were able to appreciate the rightfulness or wrongfulness due to a mental disease or defect. Two different things. But does in any way possible a defense attorney try to mush those two together? Is any of this stuff about him being incompetent for all those months prior to trial and what's occurring now, is that a valid argument for an expert to say it shows the guy's got a continuing course of mental disease and defect?
If I'm a defense attorney, I'm going to mush just like polenta, okay? Because you're trying to show that at the time he allegedly killed Phoebe, that disease and defect continues 1, 2, 3 years later. So you want to mush them. And if I'm a defense attorney, the arguments for insanity are going to be similar to the arguments for incompetency and vice versa.
Yeah, I mean, and just another strange question. Have you ever been involved in a scenario where maybe these attorneys, if they are witnessing some really bizarre things and I'm hearing things and the doctor's outside my jail cell and witnesses are talking to me when they're not in court, it could potentially create a scenario where the lawyer becomes a witness.
Oh, absolutely. And that's what's uncomfortable about a competency hearing, because a lawyer is one of the best witnesses in establishing that someone is or is not competent. So it puts them in a very uncomfortable position because they then become a fact witness. I did have to tweak you a little bit, Bob. I made a comment about polenta. You said nothing.
That's because I told you before I don't like polenta. If you said it was like making a braciole or a meatball, I would have been all over it, Gene. Last question, though. I'm curious. With what's the rule, and I think it differs, and I think it's highly within the discretion of the court, when during the course of a trial, a lawyer has to become a witness, which typically you're not allowed to do?
Well, I don't think there's a rule of evidence on that, other than, you exclude the witnesses. It's sort of an ethical obligation. Anytime I had a case where a lawyer was a witness on a key issue and they're representing the defendant, they had to get off the case. Same with a prosecutor. A prosecutor cannot be a witness in his own case.
True. But those instances in which a defendant is in the middle of a trial, and unlike a prosecutor, a defendant has a right to a counsel of his choosing or her choosing. It's a constitutional right guaranteed to them. I've seen circumstances where courts handle it differently, especially when there's two lawyers there. They've allowed the person to go in as a witness and come back out and continue to represent, or they've basically let him come in as a witness and said, you can no longer be part of the case, your co-counsel can continue.
Yeah, but probably in those cases, I'll guarantee you that the defendant did not object, the co-counsel did not object, and I assume the prosecutor did not object because they want to get this trial moving. They don't want to, slow it down. So that's probably happened. I didn't see it often in any of my cases, though.
Yeah, it's always a tricky thing. Well, listen, guys, it's been a fascinating case going through the differences between competency and insanity and what has gone on in this case. But this trial will go on because Jonchuck is capable, according to the judge's ruling. Going to break. We'll be right back.